Welcome once again to Lehto's Law. Here's Steve Lehto.
I'm guessing 50 or 60 different people sent me this story in the last 2 days. It's out of Kansas, and I've got the opinion in my hand from the Kansas Supreme Court. This is a hot topic in many states. You're driving down the road, police officer pulls you over and says, I pulled you over because you've got a license plate frame obscuring your license plate. So to give you an example, right there is a license plate from Michigan, and there's a license plate frame on top of it. And if you look at that, do you know what's being obscured? It says michigan.gov underneath the bottom portion of that license plate frame. Now, is that illegal? And it's an interesting question because if it is illegal, police can simply pull you over for having a frame like that on your car and just say, we pulled you over because you're breaking the law. Is that illegal? Well, the Kansas Supreme Court says, at least in Kansas, it is not. It is not. So they are talking about a case called State versus Beck. And back in 2021, sheriff's deputy was patrolling on I-70 when a car that Beck was driving passed him. Beck was committing no driving infractions, but a frame around his license plate partially obstructed the state name on the plate. Deputy Rose pursued the car and executed a traffic stop. After both vehicles had stopped and while still seated in his car, the officer reported to dispatch, and by the way, this is the information that sinks the entire case. He reported to dispatch that he wanted information on a license plate that was Illinois, and then he called out the license plate. So clearly, he knew it was an Illinois plate. He then approached the car and asked the man for his driver's license and proof of insurance. And he says that the man looked extremely nervous. And he explained he's driving from Springfield, Illinois to Oak Grove, Missouri, but he got lost. So the deputy was going to give the man a written warning, but because of the odd statement about his destination and his nervous behavior, he called for backup and got a canine on the scene. The dog alerted to the back driver's side door. The driver then told the deputies if they wanted to, they were free to search his car. And of course, when they searched it, they found 2.13 pounds of contraband. During the search of the car, the man ran back to his car and attempted to drive away. And the deputies had to wrestle him down in order to gain control over the situation. The state charged the man with one count of possession with the intent to distribute, a count of possessing controlled substance without proper tax stamps, and one count of interference with law enforcement. The man filed a motion to suppress, alleging that the officer lacked reasonable suspicion to stop him in the first place. The district court held an evidentiary hearing and denied the motion. He renewed the objection at trial. Court overruled him. He was found guilty in all three counts. He then appealed to the Court of Appeals. A panel of that court affirmed the conviction, and then the man petitioned this court, the Kansas Supreme Court, for review over 4 issues. One of which is the interpretation of the Kansas license plate display statute. So the court then goes into a whole bunch of discussion about traffic stops and so on, pointing out that traffic stops are seizures subject to the Fourth Amendment. Therefore, there's Fourth Amendment analysis. And the discussion focuses on a 2-prong test. The first prong is whether the officer's action was justified at its inception. The second prong is whether the detention was reasonably related in scope to circumstances. So to render the seizure constitutionally reasonable, an officer must have reasonable suspicion that an offense is occurring, has occurred, or is about to occur. Okay? And I'm emphasizing the word occur for a reason. The inquiry here is whether the officer had reasonable suspicion that the man violated any one of the multitude of applicable traffic and equipment regulations of Kansas. The validity of the vehicle stop, therefore, depends on how the statutes governing license plates are to be understood. They talk about statutory interpretation and so on. And then they point out that the Kansas statute governing the display of license plates says the license plate assigned to the vehicle shall be attached to the rear of the vehicle and shall be displayed during the current registration year or years. Every license plate shall at all times be securely fastened to the vehicle to which it is assigned to prevent the plate from swinging and at a height not less than 12 inches from the ground, measuring from the bottom of such plate. License plate shall be fastened in a place and position to be clearly visible and shall be maintained free from foreign materials and then a condition to be clearly legible. The statute makes a violation of this a misdemeanor, subject to a fine not exceeding $2,500 or imprisonment of no less than 30 days, nor more than 6 months. Now, the statute does not define what the phrase is clearly visible and free from foreign materials and clearly legible mean. However, the courts have interpreted this and construed it and applied it, and the statute's been the law of the state since 1929. It's only been discussed a few times over the years. It has been discussed, but not that many times, and that's the key. So there are a bunch of cases that discuss this, and they finally say, we accordingly reject a rule that focuses on a single fact without regard for the totality of the circumstances. When deciding whether an officer has reasonable suspicion that a driver has violated the statute, courts should apply the objective standard used in other vehicle stops implicating the Fourth Amendment. This means that courts are to decide whether a reasonable officer would have reasonable suspicion that under the totality of the circumstances, the license plate was not maintained in a condition to be clearly legible. The distance from which an officer observed the license plate may be relevant to the inquiry, but is not a controlling legal standard. And so the district court, in the present case, applied the safe following distance test originating from one court. The court said the Kansas Court of Appeals has held that a license plate or temporary tag must be clearly legible by an officer at a safe following distance. And the Court of Appeals upheld that. But the Court of Appeals went even further. It decided that the statute prohibits covering half of the state name on a license plate, regardless of its legibility. Where they got that from? Wasn't in the statute. So this determination is at odds with the conclusion of a federal district court in U.S. versus Carter, which is in Kansas. There, the court was faced with a similar factual situation where a vehicle had a license plate frame that obscured the top half of the letters spelling Ohio. The question before the court was much the same as the question now. Would a half-obscured but readable state name justify a stop for violating the Kansas statute on license plate readability? That court suppressed the evidence found in the vehicle holding the state name that was half-obscured was not difficult to read, and the officer was able to identify the van despite the partial obstruction. Court found there was no probable cause or reasonable suspicion that the vehicle was in violation of the statute. So as we explained below, we reject an analytical framework adopted by the lower courts and their conclusions of law because the state name is not part of the information required to be printed on a license plate so that it can be easily read. So the statute sets out the requirements for manufacturing license plates. The statute requires that plates generally must display a combination of letters and numbers. It also requires the letters and numerals of such license plates shall be in such contrast of colors so that they can be easily read, etc., etc. The statute further requires that each plate must display a registration decal, and it sets out what must be on the decal. So no statute requires displaying the state name in an easily readable fashion. There is no standard for how the state name is to be displayed, and the display varies greatly from design to design and from state to state. The only requirement relating to the state name is set out in a statute which requires that the name of the state, which may be abbreviated, is to be included with a display of the year or years for which it is issued. Both of those can be found on the registration decal. So the court points out that no statute requires displaying the name of the state anywhere other than on that registration decal where it may be abbreviated. So the court comes to the conclusion that the obstruction of the state name will not be deemed a statutory violation because the statutory scheme does not require that the state name be printed in such a manner as to be clearly legible. We reverse the district court ruling denying this man's motion. We reverse the convictions that are based on the admission of evidence obtained during the search of his vehicle. On the issue subject to review, we reverse the decision of the Court of Appeals affirming the convictions. Finally, we remand the case to the district court for a new hearing on whether law enforcement had constitutionally valid grounds for making a stop and seizure. Judgment of the Court of Appeals affirming is reversed on the issue subject to review. Judgment of the district court is reversed on the issue subject to review, and the case is remanded with directions. And that's the opinion. And the opinion is, I believe, 9 or 8 pages long. But the important thing here is that you're driving along and you've got a license plate frame on your car. There's a very good chance the license plate frame covers something. But what it's most likely covering is stuff that's on all license plates that is not unique to your car. So if a police officer is driving along behind that car, can the officer see the important part of that plate? Yes. And so if a state wanted to, they could pass a law and say it is illegal to have a license plate frame covering any portion of your plate. And that would be a different matter. Because if they did that, there would be an uproar from car dealerships or possibly even hamburger places, okay? And this, however, has been a thing for years. And I've seen so many cases where people got pulled over, got in all kinds of trouble, and the initial reason for the stop was a license plate frame. I remember back in the old days when you get pulled over for having something hanging from your rearview mirror. Oh, you've got obstructed view. Your view is obstructed. And I mean, I know people, I remember hearing somebody who got it pulled over because they had a graduation tassel hanging from the rearview mirror. I also know somebody else who got pulled over for having, in the old days, if you went skiing locally here in southeastern Michigan, they put this piece of metal through the pull on your zipper, and it had a colorful thing on it with a date and the name of the ski resort. And you could get that thing off and hang it on your mirror. And some people did that for whatever reason. And I actually know somebody got pulled over once. The police officer goes, "You have an obstructed view problem in your car." Oh, what's that? That thing hanging from your mirror blocks your vision. And so, if they can find an excuse, and they need an excuse, they will. They'll find an excuse. And so here the court's saying, look, no question, something was covered. But getting back to the beginning, I was reading the facts, and I said that's the thing that sank this case, was the officer got on the whole hoot and holler and goes, "I've got a vehicle, I need you to call on this plate, Illinois, blah, blah, blah." He could see that it was Illinois. Now, someone's going to say, but Steve, maybe he recognized the color combination or something. That's possible, but they said that part of the word Illinois was visible. And number two, state like Michigan, we used to only have one color combination every few years. Now we've got a whole variety of them, and they are different colors. And they say things like universities and so on, all kinds of stuff, hobbies and so on. And so the fact that the officer called it in and said, "I've got Illinois plate, Charles John," and a series of numbers, he knew what state it was from. And so don't tell me that the state was obscured when the officer could call it in. He could see it, obviously. So the court here is saying the statute as written only says that you must have portions of it displayed that matter. And again, if the legislature doesn't like that, they can change it. I can tell you this case just came down. It was decided on July 3rd. That's when the opinion was released, and it's slowly working its way out. I had a ton of people send this to me, but when I was Googling to find the actual opinion, one of the first hits I found was from a law enforcement website in Kansas notifying all police officers, hey, just to let you know, major case law just came down. And you cannot use this as an excuse anymore to pull people over. And so you pull somebody over because they've got a license plate frame partially blocking the name of the state where the plate's issued from. That won't be enough to justify the stop. Now, obviously, if it covers more of the plate, or if you got one of the reflective covers over the entire plate where you can't see it, I've seen that before. I've sat behind a car in traffic that had a cover over its entire plate that you could not see. Why they don't get pulled over every day, I don't know. But the point is that a mere license plate frame and nothing else won't do it. Likewise, if your plate is covered in mud, I've seen that, or somebody lives on a dirt road, they drove down it on a bad day, plate's covered in mud, it is covered with debris. Yes, they can pull you over for that. Say, I can't read your plate. Were you aware of that? Come back here, take a look. Your plate's all messed up. Clean that up. But here we go. So it's a good case. I agree with this. And some people are going to say, but Steve, this means a guy who had all that stuff on him walks free. Well, yeah, that happens from time to time. It's that pesky thing called the Constitution and the Bill of Rights. So there you go. State of Kansas versus Beck from the Supreme Court of Kansas. Thanks to everybody who sent it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I'm just one stomach flu away from my goal weight.